There we go. All right, I think we're right at 9:15. So let's go ahead and begin. Welcome to an oral argument session by Zoom of the Fifth District Court of Appeal. I'm Jay Cohen. Along with me today, we've got a great panel. We've got Rand Wallace and Mary Nardella, Molly Nardella, really. You can call her Molly, or you can call her Judge Nardella, whatever you want. So it's just that easy a day. This is case 21-2676 DB versus Agency for Persons with Disabilities. As I indicated, this is going to be broadcast by Zoom. So, keep that in mind because we have tens of viewers that watch these. And make sure if you have any electronic devices that they're on silent so that they don't interfere or interrupt the argument. Both sides will be entitled up to 20 minutes each for their oral argument. And the appellee can choose the amount of time for rebuttal. We have a default of 5 minutes for rebuttal. But if you'd like something different than that, Mr. Carbone, all you do is let me know, and we'll be glad to accommodate whatever you'd like on that. So that said, we are ready to proceed.
May it please the court. Good morning, Your Honors. My name is Matthew Grip. I represent the appellant, DB. And as our initial brief and reply brief show, there are several grounds upon which we feel that the order below lacks competent and substantial evidence, and the legal conclusions are clearly erroneous.
Let me start, Mr. Grip, by asking this. You make an argument about the validation by certain professionals in your brief, but it was somewhat vague. What I would like you to do is to tell me specifically what evidence you think was found not to be credible, but then was subsequently relied on by the hearing officer, and how the discrediting of that evidence impacted or played a role in the final determination by the hearing officer. Does that question make sense to you?
Yes, it does, Your Honor.
All right.
And the key
That's one of us.
Thank you. The key piece of evidence is the doctor, I believe it's pronounced Narde, report, which was done by a Florida psychologist, Dr. Narde, who validated previous test results that were done. And the test results were, of course, the IQ test and the adaptive functioning portion of that instrument. And as the lower order showed, the hearing officer, quote unquote, discredited that.
But I understand. I want you to tell me specifically, because I figured that that's the testimony that you were going to point to. I want you to tell me specifically what testimony that was, how the hearing officer then subsequently relied upon it, and how that impacted the decision.
Well, our expert, Dr. Gonzalez, testified to that report, but as we indicated, that testimony was not weighed or analyzed by the hearing officer whatsoever. So we feel. How do we know?
How do we know that?
Well, on the face of the order, there's no language to that fact. There's no indication that the evidence was considered. It's not referenced.
What indication is there that it wasn't considered? The mere fact that the hearing officer might not choose to include it into a final order doesn't mean that the hearing officer didn't consider it.
Point taken, Your Honor. I do think, though, that under the rules of the fair hearings, in that our expert and our party did have the right to bring that evidence as we did.
Mr. Grip, didn't the the hearing officer, I mean, Mr. Gonzalez's credentials were challenged as far as his testimony in front of the hearing officer, and specifically his experience in handling these types of matters in the past. There was no history of that by or with Dr. Gonzalez. Is that correct?
I'm sorry, by history, do you mean that it wasn't written down in the order?
No, I think this was the first time that he had ever testified in front of an agency such as this for specifically the disability determination. Is that correct?
I believe so. The way that the question was phrased in the hearing, he was asked, had he ever given his opinion as to the eligibility under the statutory factors, and I believe that's correct. But his extensive history of treating children with intellectual disabilities and their comorbidities was extensive.
I'm still not getting an answer, though, to my original question. I don't want to talk about Gonzalez. I want to talk about what testimony of the other expert that was discredited and subsequently relied upon by the hearing officer.
See, now I'm not sure I follow you, Your Honor. The witness that testified, Dr. Gonzalez.
Right. Is it that testimony that you're saying was not, was discredited and then subsequently relied upon?
No.
That's what I'm trying to focus you in on.
It was the Dr. Nardi report.
Right. What specific evidence in that report was discredited and then subsequently relied upon?
I believe the entirety of the report was discredited by the hearing officer. And so because the entirety of the report was discredited, the hearing officer did not take into consideration the substance of that report. And
you come to that conclusion by the fact that of what? How do you come to that conclusion?
Well, the fact that it's not written in the order, and to your point, it is possible that simply by not explicitly saying what was considered and what was not considered is a possibility. Our position is that if evidence is weighed, that the hearing officer has a responsibility to delineate that weighing and that analysis.
And what case do you cite for that proposition?
Well, on that specific point, I don't believe there was any case law that reflects that conclusion. Except for the fact that the Webb case that we point to in another part of the brief indicates that if there is evidence on the record that that shows eligibility, that the hearing officer is required to then deem the applicant eligible.
All right. Let me ask this. If we conclude that the hearing officer could rely on a GAI score, why would we, which disqualified DB, why would we have to even look at the adaptive functioning prong?
If the statute requires eligibility to be determined by the two-prong factors, and there's evidence that there's more than one score, under the administrative rule 65G 4.107, which is at issue in another section, requires that multiple scores be looked at and other factors can then be considered under this closer scrutiny analysis. And so while it is true that this GAI, which is an index and not necessarily a score, is one of the points of information that make up the full scope of
Yeah.
DB's clinical picture.
I understand that, but could the hearing officer rely on the GAI score as opposed to the FSIQ score?
We feel no. We
Right.
feel
What rule or statute would you cite for that proposition?
well, it's not explicitly written in the statute. It just says IQ score in statute 393, but in the administrative rule 65G, where this closer scrutiny process is introduced, that final sentence of that rule that says nothing precludes eligibility based on the full scale score indicates to us that the full scale score is the quote IQ score. And that's what Dr. Gonzalez testified to, that in general practice, it's understood that the full scale score is the quote IQ score. There's a number of different ways that these tests are analyzed. The GAI index looks at only a certain subset of the 10 subscores of the full scale. The full scale itself has different processing and visual type of subcategories. So these are all meant to give a full picture of the individual. And it's when state statutes and the eligibility process of the Medicaid waiver program tries to graft onto that scientific knowledge is where I think the discrepancy has come up in this case, and others, frankly, because we do feel, again, that the full scale is the appropriate measure to use in terms of the eligibility.
Okay, but I don't know that there's a specific rule that requires that, is there?
No, there isn't.
All right. Now, I understand that the legal error, and we're going to talk to Mr. Carboni about that. But is this? Do you think that this comes down to what we use is whether a determination of whether there's competent substantial evidence, or how is it that you think the court goes about analyzing some of the factual disputes, and more than disputes, there were factual errors made in that final order. How do we analyze that from your perspective?
Well, thank you for asking that, because our position is that we're requesting the court respectfully to remand the case with an order to enroll DB immediately onto the waiver, because the factual errors in the hearing and the case itself are clear on the face of the order, as you indicated. But
I know. Well, but that's you're getting past the question I asked, because that talks about what relief you get, and what I'm talking about is are we simply looking at a dispute as to whether there's competent substantial evidence, and are we at an abuse of discretion standard? Are we at what is the standard of review?
It's a competent and substantial evidence standard. Okay. And because of the factual errors and the legal errors, that the order itself lacks competent and substantial evidence.
Right. If there are factual errors, is the analysis then whether it's a harmful error or harmless error?
We believe it would be harmful error, because.
And who's got that burden?
Well, on appeal, the appellant would have the burden, I believe.
See, I'm not sure. I'm sure your opponent would thank you for that analysis, but I'm not sure that that's right. If there are factual errors that are demonstrated on the face of the order, and those are and that is error, it's a mistake, it's error, then wouldn't the appellee have the burden of showing that error didn't contribute to the final order?
That seems correct.
But that's not the position you took.
That's correct. And if we're not correcting our position, we would, of course, respect the court's ruling. Of course, but because the factual errors have that detriment to DB, the appellant, then the errors on the face of the order could be reversed in order to make DB whole.
Why wouldn't we remand as opposed to ordering that DB immediately be enrolled in the program?
Well, under the statute, 393.065 sub 5, which describes the category levels of applicants when they're deemed eligible onto the wait list in lieu of the waiver. DB was a category 7 just because of his age. So at the time of his application and his eligibility, he was within the care of the child welfare system and was in need of extended foster care services. And that means that as soon as he turned 18, under that provision of the statute, he was entitled to be enrolled onto the waiver under crisis, under category level 2. And his birthday, DB's birthday, was September 24th, which was prior to that second denial of eligibility letter. So in effect, he was entitled to be enrolled onto the waiver because he at that time was in category 2 under the Florida statute. And so remanding to correct the errors is not going to put him in the original position that he was entitled to be in under the statute.
All right, you're into your rebuttal time if you'd like to reserve the rest of that time.
Thank you, Your Honor. I would like to reserve that time.
All right. Now, is it Carbone or Carbone? I want to mispronounce your name.
Thank you, Judge. I think we changed it at Ellis Island to Carbone.
Okay, well, if that's good enough for the government, it's good enough for us.
That's what we say.
Okay.
Thank you, Your Honor, and may it please the court. This court should affirm the final order of the lower tribunal for the following 3 reasons. First, the final order was supported and amply cited to by competent substantial evidence. Second, the agency applied the correct law and procedure at all times, and any error was harmless. And lastly, any issue regarding a proposed final order is not fundamental and was not properly preserved below for appeal.
Let me. I have some questions for you. The agency seems to rely on the argument that the hearing officer was permitted to use a disqualified GAI score, over the one qualified FSIQ score. Now, and it sounds from your opening that you acknowledge there were errors in the trial court or the hearing officer's finding. And why don't those errors render suspect the final order?
Thank you for your question, Your Honor. 120.68 subsection 7B indicates that if our action is not based on that competent substantial evidence, if there's other evidence in the record that we based our decision on, then that is sufficient under 120. Yeah,
but the issue of two, the mean and two, I've got to get my terminology, but two levels below the mean or above the mean, that really seemed to be critical to the analysis, because then, DB, you don't even have to get to the second part of it. You don't have to get to the adaptive functioning prong if there isn't that first prong met. And the hearing officer seems to have relied upon that. I mean, it's not like this kid hasn't been through the school system and had years and years and years of issues. And in fact, the agency found this individual qualified. And yet, despite the fact that there were no changes of circumstances, the agency does a complete 180 and finds him to be disqualified because he's not considered, academically challenged enough. I have problems with that.
And we appreciate that, Your Honor. If you look at the record on page 1140 Bates stamp is the petitioner's application. That application is pretty bare bones. It only checks a couple of boxes. And like you said, none of those materials that show that rich demonstration of his clinical picture were presented to the agency at that time. I think Judge Evander's comments in a recent sanctions hearing are pretty prescient here, in that none of us can expect to get all of these things 100% correct 100% of the time. I think what a reviewing court, what the law says that a reviewing court should be looking at is whether or not the outcome was affected by that.
Well, but there were errors made, and we haven't really talked about the burden of proof and how that got switched in the order, and we can certainly talk about that. But even in terms of the factual mistakes that were made, isn't it your burden as the side that benefited from those errors to establish for us that those errors did not impact the final order?
Yes, Your Honor.
Okay.
So
I just want to make clear for all of us, for Mr. Grip and yourself and myself, that the agency has got to prove and establish that those factual mistakes that were made, which I think are critical mistakes. I mean, that the fact that the IQ relied upon, the GAI score that was relied upon was inaccurately relied upon. You've got to show to us that did not impact this hearing officer's decision. How do you do that?
Sure, Your Honor. Well, first, I think if we're talking about the exclusion error, which occurred on, I think, paragraph 30, I don't believe that Dr. Nady's or Nidai's report was excluded.
I'm not relying on that. I'm relying on the fact that that there was scores that were represented to be the full scale IQ that were just a subset of a test that was given. That's what I'm looking at.
Sure,
I'm not necessarily accepting Mr. Grip's analysis that report was completely rejected.
So what the rule says is when there is significant scatter or discrepancies between the domains or scales, the rule uses the term scales, of an IQ test, closer scrutiny must be applied. That happened according to the petitioner's own witnesses. The GAI score is an intelligence quotient under the rule. It qualifies under the rule, and there was testimony to that fact.
Almost anything qualifies under the rule, doesn't it?
Yes, Your Honor, as long as it's validated and scientifically backed up, which was done in this case. So the GAI qualified.
Their validation didn't seem to impress the hearing officer.
Well, Your Honor, the hearing officer is free to make that decision.
Well, no, the hearing officer is not free. The fact is that the reports were validated by professionals, and the hearing officer believed that those people had to be the ones that prepared the report, and that's wrong.
And I don't. So the hearing officer relied, though, on Dr. Nady's report, and the hearing officer also relied on second psychologist.
Did the hearing officer reject it for purposes of finding, well, it wasn't produced by the people that were qualified to do it, and then relied upon other parts of it that hurt DB? It just seems like we're cherry picking here.
No, Your Honor, the hearing officer was entirely consistent. What the hearing officer observed was that there was a discrepancy in the scores and in the domain. At that point, the rule says closer scrutiny must be triggered. Doctors Nady and the other psychologists would not have calculated that GAI score unless they thought that the full scale IQ score was not representative of his functioning. They wouldn't have made that calculation or analysis. So even they had concerns about the validity of what that test was saying. The petitioner during one of those tests was restless, he was sleepy, he couldn't complete the test. So they had to fall back on a different metric, which showed and which the experts reviewed that the GAI at that point, given the circumstances of the test, was a better indicator of his global functioning.
All right, let me ask, you didn't respond to their argument in your brief that it was error to state that the documents had to be, created by the proper professional rather than validated by the, I think I might have reversed that, but they had to be validated, and the hearing officer said that they had to be created by the proper individual. Why isn't that clear error, even without consideration of the recent case, Fatigado?
So that
However you pronounce that case.
that is not clear error, Your Honor, because the the issues were, they might have been erroneously excluded, but the rest of the evidence, the comprehensive nature of the evidence, which is what the competent substantial standard points us back to, supports the rest of the conclusions.
But they're erroneously excluded, but yet you're suggesting to us that had nothing to do with the ultimate determination by the hearing officer. Really? I mean, can you really make that statement? That the hearing officer throws out all of this evidence, doesn't consider it improperly, yet you meet your burden of showing that error had no impact upon the final order.
Well, Your Honor, I don't believe that she excluded it. In paragraph 30, that Dr. Nady's report is not excluded. She conducts an analysis in paragraph 31 of Dr. Nady's report. So that she considers his evidence. It's contrary to their position.
Didn't the hearing officer say that these reports had to be prepared by a certain professional as defined in the rules when that wasn't accurate?
I think she made two different errors that were harmless in that statement. The first, I think the petitioner pointed out that that's actually regarding, in paragraph 30, I'm assuming we're talking about, that's actually related back to the adaptive functioning. But nevertheless, even if that evidence, all of that evidence that was excluded in paragraph 30 supports our position that mental health is the true etiology of these conditions.
The hearing officer concluded that based upon an FSIQ score of 76, that DB was not intellectually disabled. And the fact is that there was no such score, was there?
No, Your Honor, that appears to be a factual error. Nevertheless, the record is supported by competent substantial evidence. Those two GAI scores.
The burden for you is to show that error did not impact the final order.
It did not. It's supported by other.
You're saying that as a conclusion, and I'm not convinced of it.
It did not, Your Honor, because there were other scores that were above that 70 threshold. For instance, the 72 score that would have essentially disqualified DB. The 78 score. So whether there was some kind of Scrivener's error with the number, the point is that evidence is still above that threshold, and the hearing officer considered it. And that's what the reviewing court looks at, is it opposed by that evidence, but is it supported? So we've got several GAI scores. We've got the testimony of Dr. Mason that says these GAI scores are a better indicator. Sure, there is a full-scale FSIQ score, but even the petitioner's witnesses admit by calculating that GAI, different intelligence quotient, that those scores are not truly accurate.
All right, let's talk about the statement in the final order where the hearing officer puts the burden of proof on DB.
Again, Your Honor, I think that that is corrected, and those concerns are harmless, because in paragraph 34, the hearing officer says specifically, the respondent has met their burden of proof to show by preponderance of the evidence that the petitioner is not eligible.
Do you know who Spiro Agnew was?
Yes, the vice president for Richard Nixon.
Yes,
He was, I think,
the indicted vice president under Richard
yes,
Nixon.
yes. I think he was eventually pardoned, right?
Well, there's a quote from Spiro Agnew that says, "Don't watch what we say, watch what we do." So you can have a hearing officer that says, "Oh, I'm holding the agency. The agency's got the burden." But then, when you look at the substance of the findings, I'm not talking about general boilerplate. The agency's met their burden. I'm talking about in the body of that order, this hearing officer switches the burden and puts the burden on DB. And I'm watching what the hearing officer did, not what the hearing officer said.
And yet, Your Honor, the hearing officer takes a lot of time and spends a lot of ink on analyzing the other scores and the other evidence that the petitioner evinced. It was the petitioner's evidence that supported our position. And in paragraph 32, I don't believe that the hearing officer was misplacing the burden. It says the undersigned finds petitioner's arguments unpersuasive due to petitioner's significant mental health during his adolescence years. And that was after the analysis, which talked about the GAI that was above that threshold. And so yes, Your Honor.
I'm sorry, continue.
I think the final order could have been more expositive, but I don't believe that the final order made fundamental or error that warrants reversal. There's an ample amount of evidence that the hearing officer could have done a better job articulating that supports this position.
Counsel, before we end today, can you respond to two arguments that have been made by your opponent? The first is the reliance on the GAI. Can the hearing officer rely on the GAI? And the second is, I'd like to hear your response to your opponent's argument about the proper relief.
Yes, Your Honor. So first, the GAI, and I think that might be the crux of the case, is the GAI, the closer scrutiny was triggered under the rule. Under 4.017, there was some dispute, some even by petitioner's admission, of the invalidity of those full-scale scores. Once that happens, you get to take a bigger global look at the full picture. The GAI and that analysis was part of that process. The GAI is, as the expert explained below, is an intelligence quotient. It's not presumptively valid. It's not a full scale, but it certainly is an intelligence quotient. And further, the psychologist would not have calculated that measure if they did not believe that the full scale IQ was not an accurate representation of their functioning. As far as the relief, I believe that 120.68 has a very circumscribed set of relief that this court can order. I believe that the errors have to be harmful. I think that is in both 120.68 B, Bravo, and 120.687D Delta, that the agency had to erroneously interpret a provisional law, and the correct interpretation compels a particular action. So I believe that I think
you all are conflating some of these concepts. Yes, typically error has to be harmful, but it's your burden to establish, because there was error, that the error didn't impact the order. Right?
Yes, Your Honor.
Okay.
And there are other GAI scores,
Right.
and there is the
Oh,
other.
let's talk about the relief, because I think that I agree with Judge Nardella that that's an issue we should be talking about. Let's assume that we think that this hearing officer made errors that impacted the result, the final order in the case. What's the appropriate relief?
It would be, I think, to remand the case for further proceedings to correct those errors, and then to see how, if at all, that would have affected the outcome.
All right. Anything further?
I'd like to reserve the last 1:15 that I've got for rebuttal.
No, you don't get rebuttal. You're the appellee.
That's what I thought, Your Honor. That's why I was a little confused about the instructions in the beginning.
All right. That was for the appellant, not for the appellee.
Understood. Your Honor, even though there were errors committed, they didn't change the result. And further, you can look throughout the record and the final order that there are other scores that the hearing officer both relied on and that are both present in the record that establish from the 78 score down to the 72 score in the GAI that established that DB was not eligible. And it's for those reasons that this court should affirm the final order below. Thank you.
All right. Thank you, Mr. Kerpo. All right, Mr. Grip, you've got just under 5 minutes, sir.
Mr. Grip, before you get too far down the road, I believe when you were ending your argument, your first part, you had said that once the appellant reaches the age of 18, it's an automatic transition into the waiver. Is that correct? Or is it because there was a request for residential placement that the agency was still permitted to reevaluate?
You got, there you go.
Apologies.
We all do that, by the way.
Yeah, thank you. Well, to answer your two-part question, our position is that the agency does not have the discretion to do a reevaluation. But as a reading of section 393 of the priority ratings, it doesn't happen automatically. The agency has to manually place someone from the waiting list to the waiver. But under the statute, the way that it reads, it says that once you're in category 2, in essence, you're entitled to be on the waiver. You're 18, you're between the ages of 18 and 22, you're in the care of the child welfare system, and you're in need of extended foster care, which all apply to DB. And so as soon as he turned 18, he was entitled to be transferred to the waiver under that priority category. But because this reevaluation process had already begun, that second denial occurred, maybe a week after his 18th birthday, which, by the way, doesn't make mention of any of that. On the face of it, it looks like a standard non-eligibility in the first instance letter. So our reading of the process, this second reevaluation happened internally over time, possibly because there's nothing in statute or in the Florida Administrative Code or in the internal letters that the agency pointed to, or in the federal code of regulations guiding and requiring Medicaid processes at the state level. Nothing gives the state agency the authority to do this reevaluation.
Counsel, I'm interested in that as well. What Judge Walsh was hitting on. I have a couple of questions about the reevaluation, and I think you were getting into them. One, why doesn't the agency have an inherent power to reevaluate at the time services are being offered? Is your answer anything other than the statutory section that we were just talking about? And two, what is the difference between an eligibility determination and a level of care determination? Are they sometimes interchangeable?
Thank you, Your Honor. In essence, you're right. We point to the statutes and the rules And there is no inherent power to do this quote reevaluation because this Medicaid program is very much determined by the strict guidelines. In other parts of Medicaid, which are means tested and income driven, the reevaluation of income is extensively delineated. And under these rules, it's assumed, and it's written into the rules, that when someone is eligible for these home and community-based services, they're deemed eligible. There's no need to redetermine someone because it's already been done that they have this intellectual disability, it's within the period, and it's going to last them for the rest of their life. They're making a determination that there's no possibility that this person is going to get better. And the difference between that and level of care is that these home services are designed to keep people out of institutions. And as you might imagine, some people devolve in their need to be institutionalized. And so the agency, as we grant, has a duty to do these annual reevaluations for level of care to ensure that people don't slip through the cracks and they get the services that they need. But that's a separate issue from eligibility under the statute and under the eligibility rules.
Does level of care ever result in less services, or can level of care ever result in no services being offered?
To be honest, Your Honor, I don't know the full history and the full extent, but to my understanding is it's always an increase in service because someone either devolves and needs to be institutionalized or needs more services like more home health care or different devices, or frankly, they pass away and then they have no more need and they're taken off of the rolls. And with that, I yield. Thank you, Your Honors, for your time and consideration.
All right. Thank you both for your argument this morning. And so, we've got another case that we're going to be doing live. So we're going to get off the Zoom, go back into the courtroom, and we'll get a ruling to you just as quickly as we can. So thank you both.
Thank you.
Thank you, Your Honors.